It is my great pleasure to welcome you today to our session from the Dear Colleague series. My name is Matthew Countryman. I am an associate professor of history and in the Department of Afro-American and African Studies here at the University of Michigan, and I will be the moderator for today's webinar. This event series, Dear Colleagues, is sponsored by the National Center for Institutional Diversity, the Michigan Program for Advancing Cultural Transformation, and the Center for Social Solutions. We know this to be a contentious time. We are committed to uplifting the voices and works of academic experts. To do this, we draw upon academic freedoms as outlined in the American Association of University Professors 1940 Statement of Principles on Academic Freedom and Tenure, University of Michigan's SACWA Senate Assembly Statement on Academic Freedom, and University of Michigan's Standard Practices Guide on Freedom of Speech and Artistic Expression. Some perspectives expressed during this event may differ from those of the sponsoring units or of the University of Michigan, and we present a forum for these perspectives to deepen and broaden our knowledge of the subject matter. The series is an opportunity for us to come together and gain a deeper understanding of the historical and current higher education efforts in advancing diversity, equity, and inclusion. To acquire the tools to interpret the current campaign against DEI and to build the skills and courage to collectively reaffirm our commitment to diversity, equity, and inclusion in higher education. As part of this series, I want to set a shared definition for diversity, equity, and inclusion. We know that talent is distributed across all communities, but opportunity is not. Cultivating a diverse campus community, including removing barriers to higher education access, enables the type of culturally and intellectually rich learning and working environments necessary for a world-class education, catalyzing new knowledge production and innovations, and developing solutions that positively impact society. In order to best nurture and benefit from a diverse campus community, we must create and sustain the conditions of equity and inclusion that allow all campus members to participate and thrive. Decades of evidence demonstrate the educational and societal benefits of diversity, equity, and inclusion, improving student outcomes, preparing a skilled workforce to address the needs of our society, and advancing research and innovations that offer solutions to our most pressing health, economic, and environmental challenges. In 2020, an executive order was signed to prohibit diversity, equity, and inclusion trainings within the federal government. While this order was quickly overturned, beginning in 2021, we saw an organized and well-funded campaign against diversity, equity, and inclusion programs in the education system, with hundreds of bills introduced across states to restrict teaching, training, and learning in K-12 and higher education. Over the past couple of months, the Trump administration has intensified the political campaign against DEI, with additional executive orders and directives targeting academic institutions. The ongoing attacks on education signal the important role that the sector plays in our society. At a fundamental level, education socializes citizens around sociocultural values, norms, and expectations, and teaches them to think critically and analytically about complex issues. The attacks on academic institutions and higher education in particular undermine academic freedom and the autonomy for educators to determine curricula and for researchers to freely and openly pursue scientific and other forms of scholarly inquiry. Restricting and censoring higher education institutions' efforts to advance diversity, equity, and inclusion threaten social progress made to rectify the long-standing history of systematic and structural inequalities in the United States. Our goal for this event is to offer expertise and to be honest and truthful. While this event series was designed well in advance, in the last week, the topic for discussion today has become even more relevant, in particular here at the University of Michigan. Referencing the federal directives, the University of Michigan executive leadership has decided to close out its DEI strategic plan 2.0 strategic plan, including closing the Office of Diversity, Equity, and Inclusion and the Office for Health, Equity, and Inclusion, and laying off dedicated staffs who've worked tirelessly on these initiatives. While each of you may be listening within a different institutional context, and we welcome those of you not from U of M, and we're so excited that you've come to join us today. We hope that this event will offer you community, knowledge, and strategies to face the pressures that we all encounter as we interpret and navigate policies that affect the core functions of the university, um, while trying to anticipate what might come next. Without further ado, I would like to welcome our two legal and policy experts, Liliana Garces, Ken McIntyre Professor of Excellence in School Leadership at the University of Texas at Austin, Samuel Bagenstos, Arlene Susan Cohen Professor of Social Policy, and Frank G. Millard Professor of Law at the University of Michigan. Throughout our discussion today, we will have the privilege to discuss and unpack with them the current legal context. They will offer guidance for our higher education community on how best to understand the legal scope and limits of federal directives, navigate potential risks, and uphold academic freedom and institutional autonomy with evolving legal parameters. And with that, let me turn to Sam and Liliana. Sam, as someone who has served in a presidential administration, not the current one, and has experience navigating policy changes, could you share a bit about your background and how your experience shapes your views of the recent directives on DEI?
Yeah, for sure. And thank you. And thanks to so many people who are here. I see we're well over 900 people on the line. So I am now a professor at the University of Michigan, where I've been for the past 15 years or so. But I've taken 2 leaves from my job at the University of Michigan to serve in the federal government. During the Obama administration, I worked in the Department of Justice as the Principal Deputy Assistant Attorney General for Civil Rights. So did a lot of civil rights enforcement, including enforcing, many of the laws that people are trying to make sure they comply with when they're engaging in DEI programming. And then in the Biden administration, I served as the general counsel at the Office of Management and Budget for the first year and a half, where I, among other things, ran the executive order process within the White House, and then spent the rest of the administration as general counsel at the Department of Health and Human Services, which has played a very significant role in the first few months of the second Trump administration in trying to go after what they're, I think, misleadingly calling or threateningly calling illegal DEI programming. So, the perspective that I have from that work is to see a very substantial overreach on the part of the current Trump administration, trying to suggest and intimidate people into thinking that DEI programming is inherently unlawful, when in fact DEI programming of many, 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 many kinds is perfectly lawful. And happy to talk about those issues as we go forward.
Thanks so much, Sam. And Liliana, as a leading legal and higher education scholar, you have played a key role in litigation on race-conscious admissions as a counsel of record in friend of the court briefs filed before the U.S. Supreme Court. Could you share a bit about your work and how it informs your understandings and actions in today's climate?
Thank you. Well, I want to start by just thanking you for the opportunity to be in community during this time, and really begin acknowledging the heaviness that many many in the University of Michigan community and others who care about your community may be feeling at this moment. I know we're here because we've worked to advance goals to promote equal access and opportunity, to ensure that our students can meet their highest potential and aspirations, regardless of race or any other marginalized identity. And these are all goals and values that really require an environment where we feel empowered in our ability to support our students to pursue bold and unconventional ideas, as you mentioned, through our research without fear of censorship or reprisal. And we're all striving, that's what we're striving for with these sessions. And so thank you for the opportunity to join. Now to address your question, I'm a trained lawyer. My partner likes to call me a recovering one. After that legal training, I clerked for federal judge in U.S. District Court. I was a lawyer for the American Civil Liberties Union and litigated cases before the U.S. Supreme Court on immigrant rights issues. And I'm also a trained social scientist. And in my research, I examine how the law and education policies come together to shape educational opportunity and social inequality. And so I come to this conversation with that lens as an education researcher and a legal scholar, And all my comments are grounded from that research expertise. I should say nothing that we should say today should be interpreted as legal advice. And a lot of my work has involved conducting research to inform legal cases, as well as translating those findings to inform the findings from social science research to inform the development of those cases that then have implications for education policy. Most recently, I served as co-counsel in an amicus brief that was filed in the Harvard case by 1,241 social scientists. This is a topic on affirmative action. I know it's a topic that generates a lot of strong opinions. It has been at the core of how we as a society promote ideals of equal access and opportunity, fairness, and our ability to advance the freedom for students to realize their full potential. And it's in these legal cases that come down to how we interpret legal provisions, particularly the Equal Protection Clause of the 14th Amendment. And through those interpretations, what we really want is for race not to matter, right? That is the end goal. The question is how we achieve that goal. Research shows us that we get there by being attentive to the barriers that exist so that we can ensure a fair system, that we ensure equal protection when we recognize the inequities at play, and then we act to make sure that laws and policies are not creating those inequities, and to the extent that they are, that we remove the barriers. And what we're witnessing and experiencing in this current climate that has been building up is the imposition of a very different perspective, one that sociologists would call color blindness or race evasiveness, that says that existing inequities are not relevant to that determination, that we have to be blind to them, that the only consideration is whether laws or policies make distinctions on the basis of race. That just thinking about those distinctions constitutes discrimination. Of course, when you erase that context of inequality and you characterize laws that attend to race as, it allows you to characterize these laws as those that attend to preferences or that promote discrimination. And what we're seeing is the imposition of this ideology and this perspective through guidance around how to interpret legal decisions, state laws, and executive orders, so that educators are forced to change their practices. And unfortunately, it's a perspective that is not supported by empirical research, and it ultimately restrains our ability as educators from advancing the values that are integral to our educational mission. So that's the perspective that I bring in understanding how these two systems come together.
Thank you so much, Liliana. Sam, let me turn back to you. On February 20th, a memo signed by law professors, including yourself, was issued in response to President Trump's January 21st executive order entitled Ending Illegal Discrimination and Restoring Merit-Based Opportunity, as well as the subsequent Department of Education Dear Colleague letter. In the memo, you and your colleagues argue that diversity, equity, and inclusion initiatives are legally defensible and warned against unnecessary eliminations. Can you summarize your arguments and also share how this group of law professors came together to write the memo?
Yeah, absolutely. So, the origin of the memo was, I think a lot of us, read this Dear Colleague letter in particular that had been issued by the Department of Education and thought it went way beyond what the law actually says, and suggested to schools, universities around the country that they could not legally do things that were actually perfectly legal. A lot of folks were wondering what to do about that. A law professor at Boston University, Jonathan Feingold, sort of pulled people together who were experts in the area and said, folks in universities, in university general counsel's offices, right now they're only hearing this one side, which is very skewed of the legal issues, and we really need to present to them what the actual law is. And so that was the origin. And, I think there was just a lot of desire to, work on something that gave an objective account of the law. So here's the point that we made essentially in this memo, which is still available on the web and circulating around. Number one, the Supreme Court's decision in the Harvard case, which you've already heard Liliana refer to, did make a change in the law, at least nationwide. It didn't actually here in Michigan, but it did make a change in the law nationwide. But the change was a very particular change. Before the Harvard case, the Supreme Court had interpreted the 14th Amendment and Title VI of the Civil Rights Act to permit the use of affirmative action in admissions that would give some additional weight to diversity, including racial diversity in the admissions process, so long as that additional weight was used as part of a holistic process and was, serving the compelling interest in diversity in a narrowly tailored way. So it wasn't, giving an absolute preference. It wasn't giving some strict numerical score. It was just including this as one weight, one factor among many, many factors that were being applied in an individualized way. What the Supreme Court said in the Harvard case is no, 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 no. To the extent that you are looking at somebody, identifying their race, and using their race as a factor at all to benefit or burden that person, that's something that is extremely unlikely ever to be constitutional. It's not going to satisfy strict scrutiny. Diversity is no longer, at least in this context, a compelling interest. Now, interestingly, the court wrote the opinion in a very, sort of slippery way, so didn't purport to overrule the prior cases that it upheld diversity-based affirmative action, but nonetheless pretty clearly meant to do that. But note what I said. The limitation of the holding of the Supreme Court is when you as an individual or you as an entity look at an individual, identify that person's race, and give that person better or worse treatment because of their race, even if it's only one factor. That is not at all an endorsement of this idea, this very strict color blindness idea that in adopting a policy that treats everybody equally, that doesn't identify individuals on the basis of their race and give those individuals better or worse treatment because of their race. The colorblind idea that even in adopting a policy like that, you can't even have race on the mind. So there is a view, which is the view that underlay the Dear Colleague letter, that if what an entity is trying to do is reduce racial gaps, overcome racial barriers, then even if it acts in a way that is on its face race neutral, it cannot do so. So the Dear Colleague letter said, for example, if what you're doing is getting rid of reliance on standardized test scores because you think standardized test scores create a specifically racial barrier, that's not something you're allowed to do. To the extent the Dear Colleague letter said that, that is simply wrong. The Dear Colleague letter suggested that if there are discussions of racially charged issues in classrooms, and that makes some members of a majority race, some white people, feel worse about themselves, that might be a racially discriminatory act that's unlawful. That is not true. And so what we tried to do in this memo is go through and say, look, there are all these things that are perfectly lawful, notwithstanding the insinuations in the Dear Colleague letter. And all these things, including various kind of programming that are calling attention to particular kinds of racial or sex-based inequalities in society. Allowing people to talk about the way that they have overcome bias as part of an admissions process. Allowing people to work together and join together in affinity groups, so long as they're not closed off to people based on their race. Having tracking of what are the racial results of your decision-making processes so that you can go back and identify the places where bias is creeping in to your decision-making processes and eliminate them so that you're actually making decisions based on merit and not based on bias. I mean, it's this sort of topsy-turvy world that the Dear Colleague letter and some of the other statements from the administration are putting us into, where the efforts to overcome bias in the world and actually that would lead to selection on the basis of merit are determined to be inherently against merit. So what we tried to do is just sort of go through all of those ways in which programming that has come under the heading of DEI is perfectly lawful, notwithstanding the statements or suggestions or insinuations of the administration.
Thanks so much, Sam. Liliana, I'm going to ask you a sort of follow-up question that's very similar. You recently published an article in the Chronicle of Higher Education in which you make a similar argument that the Dear Colleague letter is making demands on institutions without proper legal authority. Can you say some more about both about why you think the Department of Education is overstepping its bounds and what you think, how you think institutions of higher education can respond?
Sure. Yeah, and here I'll mention some of the points that Sam mentioned because I think they're worth repeating. And that's a piece where I really wanted to bring attention to the fact that the content of the letter, which is not law, it's supposed to really stay within the parameters of providing guidance around how to interpret the decision, was actually it was changing that interpretation, and it does not have the proper authority to do that. The case had to do with the methods that institutions could use in their admissions processes to promote a goal of diversity. And the court said that someone's racial status could not be used as a determinative factor in that decision. You can't provide that kind of benefit based on a student's racial status on its own. And it also said, and here I really like to use the words of the court, the court's decision itself, that nothing in the opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected their life, be it through discrimination, inspiration, or otherwise. So in other words, institutions could still consider an applicant's lived experience in relation to race and how that might contribute to the mission of a program, a department, an institution. The case did not place restrictions on the goal of diversity itself, and especially when that goal is rooted in the university's mission. Chief Justice John Roberts, who wrote the opinion, called the diversity interest worthy and commendable. Granted, they erased 40 years of precedent, saying that it had been a compelling interest, but the decision didn't say, as the letter suggests, that you couldn't pursue that goal. It was around the methods that you could use to pursue a goal that was grounded in an institution's mission. And the letter defies that ruling. It goes as far as saying that even race-neutral efforts are not permissible. And those are efforts that don't even consider race, but aim to achieve the goal of diversity. There were also arguments that were brought in other litigation and other cases. Lower courts have rejected them. The Supreme Court, with its current composition, let that stand. And so what we see in the letter in the subsequent question and answer document is an effort to rewrite the court's decision, to expand the parameters beyond what the court said in the Harvard case, which only applied to the methods that institutions use to achieve their goals. And what it's doing is it's trying to dictate the very goals that institutions and education professionals can think about. In other words, you have the government imposing its own views of how schools and universities should operate. And the First Amendment prevents the government from doing that. It prevents the government from censoring, from discriminating, or applying rules inconsistently based on a content or viewpoint perspective. And it protects institutions from laws that are so overbroad that it ends up prohibiting protected speech and expressive conduct. And those are some of the legal arguments that have now emerged in litigation against the legality of the Dear Colleague letter in the subsequent frequently asked questions document, with cases right now pending on the merits of that litigation.
Thank you so much, Liliana. Sam, I'm going to come back to you and ask you to talk a little bit about the specific context here in Michigan. You obviously know about that Michigan has operated under Prop 2, the ban on affirmative action, since 2006. And yet we fortunately, and at least for the time being, don't have any anti-DEI state laws such as they have in Florida and Texas, and as were recently passed in Ohio. Can you remind reviewers about the context in Michigan and what that allows us to do differently than from those institutions and states with that anti-DEI legislation?
Yeah, so I think that that's a very important bit of context. So, since 2006, we have had in our state constitution Proposal 2, which prohibits discriminating against or providing preferential treatment to anyone on the basis of, among other things, race, in particularly education programs, but a number of other government programs. That was adopted at a referendum by the people of Michigan following the Supreme Court's decision in the Grutter case, which had upheld the affirmative action program at the University of Michigan Law School, where I teach, which was held to be sufficiently individualized. It was taking account of race as one of many factors, not in some rigid numerical way. And a political campaign arose to prohibit even that. What that did, starting in 2006, is essentially the same thing the US Supreme Court in the Harvard case just did for the 14th Amendment in the entire country. So we have in Michigan for the last nearly 20 years been living under the regime that the Supreme Court imposed, which, as I said, allows for very significant DEI programming, so long as it does not identify people based on their race and give them favorable or less favorable treatment because of their race. You can still be trying to achieve racial integration. You can still be trying to overcome racial inequality, achieve diversity as a valuable goal. What you can't do is say, because this person is of this particular race, they get a little bit favorable or a little bit unfavorable treatment. That is no longer allowed. That's been true in Michigan for nearly 20 years, and we at the University of Michigan have complied with that. And I think that's very important. So there's been no change in the legal regime that applies to the University of Michigan that would require us to pull back on anything we've been doing. And I will say everything that folks at Michigan have done through the years has been done working very closely with our general counsel's office, who takes these issues very seriously. So there's no change in the legal regime. The change is in the administration and how they are aggressively trying to act like, in the United States as a whole, laws like the ones you've referenced in Florida have been adopted, but they haven't. There is no law in the United States as a whole that prohibits DEI programming. Doing so would raise very significant First Amendment issues, very significant academic freedom issues as applied to college campuses. Instead, the prohibition that applies to us is the prohibition that has applied since 2006. Don't classify people based on their race and give those people better or worse treatment. There's no prohibition on caring about and taking effective action about racial inequality, racial segregation, including de facto racial segregation, racial gaps, racial division.
Thanks so much. Turning back to you, Liliana, I want to ask you to talk a little bit about how the current context shapes people's research. You've done extensive research on race and education, along with studying the ways in which scholars have been targeted for doing that kind of research. And that's positions you to uniquely address how we might think about the current challenges. What do you identify as the biggest threats to the research enterprise? How can student researchers, staff researchers, and faculty effectively navigate and protect their work in this climate?
Yeah, so, I think there's all these provisions that orders that are very problematic, they're unlawful, they're being challenged in the courts. It's critical to be informed about the legal arguments at our disposal for understanding the illegality of these orders and other actions. And Sam mentioned, the working law that individuals and institutions might be within, but we can understand all those legal parameters, but we also need to attend to the fact that there's a broader environment that is leading to a lot of fear, because even if you understand those legal parameters, the laws may be struck down, it might still lead institutions to change their policies. And to understand that, for example, the Dear Colleague letter is part of a broader ecology of other pressures that institutions have been facing. There had been the threat of ongoing litigation after the Harvard case, the anti-DEI legislation in a lot of other states, including my own here in Texas. And you have a host of executive orders. You have actions that PEN America has called job owning strategies, where individuals use their positional authority to cause institutions and others to change policies without even having to introduce legislation. And these are all actions, they are all part of a larger environment that contribute to a climate of suppression, where educators and administrators feel the pressure to abandon efforts that promote fair access and opportunities out of concern that they represent a legal risk. They perceive the environment as requiring that, even though the actions might remain lawful. And as a researcher, I've seen this dynamic on the ground in my research, so much so I've been able to give it a name. I call it repressive legalism, when our perception of those pressures lead us to engage in work that remains to suppress work that remains lawful and essential to advancing our educational mission. And in research with my team of graduate students and postdoctoral students over the last several years, where we've examined how faculty have responded to an environment where there might be proposed anti-DEI legislation. And what we've learned is that when the bills are proposed before they're even enacted, it's led to the suppression of protected activity. Faculty have changed the content in their syllabi. They removed readings. They've changed how they might go about teaching on particular topics. They've changed their research dissemination strategies out of concern that they might be targeted. And many have even left their institutions altogether. And those responses come from faculty feeling isolated, feeling alone, and needing to protect themselves from becoming a target. And those feelings of isolation were particularly prevalent at institutions where leaders remained silent or adopted a wait and see approach, or may have downplayed the concerns that faculty or students expressed. And they're all very rational. They're understandable responses to the larger environment. Institutional leaders are in a very challenging spot. A lot of these laws are vague, and intentionally so. The words aren't clear, they're subject to interpretation, and that interpretation involves a balance of risk. And right now we're in an environment where the balance of risk is being very strong, and we have undue weight on these perceptions that you might be seen as not complying versus the risk that the actions, when taken together, end up really suppressing and undermining the educational mission of institutions of higher education. I wrote a piece with collaborators that bring attention to this environment recently, just this week, that was published in the Change Magazine of Higher Learning, trying to really bring attention to the fact that it's not these individual actions, it's not just a chilling effect that we experience, it's a repressive environment that we need to attend to with very strategic responses that bring us together in coalition and don't leave us isolated in our actions.
Thank you so much, Liliana. So in your last two answers, the two of you have really laid out, I think, very effectively the gap between what's legally permissible and what the kind of institutional context, both political and financial and all the other aspects of what that people are having to navigate in this moment. So now I'm going to ask you the really important question. What is to be done? What suggestions do you have for how all the people who care deeply on this call can respond to this really unprecedented context? As they think about their own work. And Sam, why don't you go first?
Yeah, and I'll go quickly because I know that we want to leave some time for questions. I mean, I think that number one, there is a lot of organizing going around among faculty to do a few things. One, pressure one's own institutions to stand up for well-warranted programs that are compliant with the law, to join together across institutions, both as faculty and encouraging the institutional leadership to do so as well. And so, we see that through entities like AAUP, through various professional organizations as well. But the dynamic that we're seeing is that there is an effort by the Trump administration to intimidate folks at particular institutions into backing away from well-warranted programming that is legally defensible, and to pick off the institutions one at a time. And the only way that there can be an effective response to that is if institutions join together. Because otherwise, everybody's incentive is essentially to duck their head, hope that they're not the target, and hope that somebody else is. And what happens then is that these extra legal, beyond legal efforts end up picking up momentum, just as Liliana was just saying. And then it becomes too late to actually respond to them. So we really need folks to join together on this.
Yes, agreed. I think one of the elements that we need in some respects too is to reorient ourselves to how we've generally approached the law, for example, right? Like we need to remember the fact that just because something is written in a legislative bill or an executive order or some other policy does not mean it's lawful. The fact that it's in that in a policy, let me just repeat that, it does not make it legal. And we need to understand that these policies and these actions are being used to advance that perspective that I mentioned that is very much at odds with the educational mission of institutions of higher education. And we have agency in how we respond. We have collective power in our responses. These policies do not implement themselves. We give them meaning through our actions, and we can build that collective power through the coalitions and with partnerships with others outside and within our institutions. Administrators, faculty, students, we're all part of the same system. From my research, I've learned that faculty were able to resist the pressure that they felt to change their work when they heard their chairs, their deans vocalize their values, who chairs or deans who connected the work that faculty do to the very values of the college or the institution, and to the rights and the responsibilities under academic freedom. Faculty were able to stay the course and resist those pressures, also when they worked in coalition with advocacy organizations that help provide guidance about activities that were protected. These are really important times to be in coalition to disrupt that sense of isolation, that allows the fear to thrive. And I would say really leaning into our values as missions in the mission of institutions of higher education. We need to resist politically motivated intrusions into our scholarship and learning. And these laws, these policies, they don't erase the context of inequality that we're facing, that our students face. They can't change the values that we hold, but we can't do it in isolation. We have to see our work as a collective in service of a common good for the role of institutions of higher education and for society more generally.
Well, I'm gonna thank you both for those comments. We have had a lot of questions in the chat, and I'm gonna ask one that sort of pulls together a number of them. I think you both made strong cases for the kinds of action and what would be the ideal set of actions. But I ask you a question. It's about what happens when individual institutions essentially go beyond the law to restrict activities, and then how again what can people within those communities, how can they respond when institutions make decisions that are clearly is based as much on the political context, concerns about federal funding. There's a wonderful question about what about institutions that are that are tuition dependent and don't have the kind of endowment resources that some of these larger institutions have been attacked with. Um, so it's again this sort of there's the kind of we would love institutions to do more, but when they don't, how do we respond? Whichever one of you wants to.
I'll start very quickly and then kick it over. I mean, I think number one, it is really up to the institutions in the first instance. So yes, we would love them to respond, and I think there are very limited things that we can do other than organizing to put pressure on our institutions generally in the political system to try to get to, get to good answers here. I think it is certainly incumbent on us as faculty and people who are otherwise related to institutions but are not in leadership to do what we can to support our students. I mean, one of the things that we're seeing here is as universities are backing away from perfectly valid programming without legal requirement to do so, they may be saving themselves from, the aggressive actions of the current administration, but they're also leaving a bunch of students in the lurch. And sometimes that's in a very concrete way. Like people are being deprived of financial resources that they depended on. People are being deprived of programming that's essential to their education. And we need to figure out what we can do on a local basis as faculty, individually and collectively, to help those students. To me, that's sort of the number one thing that we can try to do. But I think it's going to be different at different institutions. And I think the biggest thing is right now, the leaders of our schools, they have one thing they're afraid of, which is the Trump administration is going to take away their money. And we need to be working to make sure that that is less of a threat because there are effective legal challenges to what the administration is doing beyond the law. And that they also see that there are folks who they care about who are going to be hurt and who are going to put pressure on them if they do make concessions that they don't need to make.
I think that's a very comprehensive and effective response. I don't have anything to add. I want to let you get to other questions.
So I'm going to go and synthesize a couple other questions that have to do with the challenge of the political context from the outside, off of campus, and particularly perceptions of institutions as liberal bastions, as uninterested in other political perspectives, as ideologically biased in terms of how they hire faculty. How does both that shape this context, and what kinds of responses can those who are supportive of the academic mission, academic freedom, the research enterprise, what kinds of responses can we make to that?
I'll start with tackling that a little bit. I think we promote freedom of expression and academic freedom, not by constraining one another, but by having the kind of environment that allows us to pursue the scholarship without fear of censorship or restraint. And so if we have that perspective, we're aiming for the same goal of needing to have an environment that allows us to advance our mission. I think that many of us in higher education right now have been caught in a very defensive stance on an issue that has been defined by those who are targeting it and trying to really restrict efforts that promote access and opportunity. And we're seeing through, as the legal cases have come up, court decisions that are uplifting a different narrative, that are showing that these are policies that are unconstitutional and that are infringing on protected rights. And we need to not be so caught in that defensive stance, but uplift the narrative of what education promotes, the freedoms that it fosters for everyone. And the fact that when we get rid of the supports, when we're not able to attend to the barriers to educational opportunities, we are allowing discrimination to continue. When we remove the policies that allows us to open access, we're making it much more challenging to support students' educational experiences. And at the end of the day, they are robbing us of the opportunity to come together and to understand each other's experience. We live in such a segregated society that higher education provides the opportunity for the very first time for so many students to understand each other across racial lines. And that is what really we're trying to do in order to promote the freedom that we all deserve to understand each other's experiences. We shouldn't be letting somebody tell us how it is that we should feel about one another. We need to come together to understand how we can create the educational environment that supports students in coming together, because right now we need that more than ever.
Yeah, I don't think I have anything to add there, and I know we don't have a lot of time, so maybe we could do the next question.
Sure, happy to ask a question. We have a question here about whether or not you all are recommending that institutions sacrifice their research funds in order to their federal research funds, the hundreds of millions of dollars, in order to pursue the goals we've laid out here.
I mean, I think number one, there are very good legal challenges that schools can make. I have, publicly written and spoken about Columbia, for example, that, they decided that they would negotiate and make very, very substantial concessions to the current administration because the current administration said they were taking away $400 million in research funding. Um, as I have written, and a number of other legal scholars and lawyers have written, they had very good legal claims. They could have gone to court to challenge that instead of making these concessions. It turned out they made these concessions, and what the administration said was, "That's very nice. Thank you very much. Now that you've made those concessions, we can talk about what further concessions you're going to make." I think we're in a cycle here where, someone needs to stand up for their legal rights. And I totally understand why it's a collective action problem. Institutional leaders will think it's not in the interest of any one institution to do this fight, but it is essential for the academy as a whole that this happens. I also will say in the New York Times just yesterday, Larry Summers, not a raging leftist by any means, said this is exactly what university endowments are for. Obviously, we want to preserve university endowments. We don't want to tap into them, but why do we have them but for emergencies like this? And so, I think that's an important part of the conversation as well. That obviously only affects a very privileged fraction of universities. And I think that's important, and that's why collective action is so important as well.
Thank you. Liliana, as we get close to the end, I'm going to combine two questions and direct it to ask you for you to start with. One is from someone who works in a mental health and counseling center on campus and has a question about how to protect students in affinity groups given the targeting and how to manage the tension between trying to avoid targeting and standing up for values. And then a broader question relates to the role of staff not in high leadership positions. How do they navigate unclear guidelines? What kinds of action can they take?
I think, at the end of the day, being there for our students is the most important element. And I know as faculty, particularly faculty who are in tenured positions, who can feel much more protected in their position, we can do that for students, and that's something that has happened even before the current context, where what students will turn to faculty who help them feel that they're seen, that they're represented, that they're valued, and that work will just continue. And it does place, I think, an undue burden on faculty who are also feeling the target themselves. But that is something that we all do need to support, to be mindful, and to come together in community. I missed the second part of your question. I think that was the first part.
About just
Can you
more
just remind
generally
me?
for staff, how can they navigate the current situation, unclear guidance from those at the top, um, manage the kinds of risks inherent for them in this moment.
Yeah, I think that's where the community of our colleagues in our department, in our chairs, in our colleges become really critical and important to for for those who can express their voice and values to express them in the spaces when they can, because especially staff who are in a very precarious position, we need to feel that support, and that's something too that came very clear in our research is that when those voices were there, whether they don't need to be public statements, they can also be they can just be spaces for discussion where we can come together in community, which is challenging to do because within higher education we have all these silos, but we need to disrupt those silos and create the community to come together.
We have so many good questions, but we're close to time. So what I really want to do at this point is just ask the two of you for your final thoughts and suggestions as people move forward in this difficult situation.
I would just say, stay engaged in this, keep working on a local level, on a community level with the folks at your institution to try to get your institutions to work with other institutions. Again, it's really, this is an academy-wide problem, and it's something that needs an academy-wide solution. And so the more we can work together across our differences, our different places, the better we're better off we're going to be.
I think we're facing a challenge of needing to be much more fluent in the ways that race shapes educational opportunity. These legal cases well before the current environment have led us to a constrained space of addressing diversity as a goal, which is very important. It's very important for addressing very important educational benefits for our society. But at the end of the day, there's also a lot of barriers their students are facing, and we need to reclaim and regain our ability to be racially literate in how we can attend to those barriers, particularly in a context right now that is removing our ability to do that by just tending to race, we are engaging in discrimination. That is not something that um, we can do on our own, and it really inherently cuts at the very mission of institutions of higher education. And I think advancing a new narrative, because the language of diversity, equity, and inclusion has also been very vilified. And to the extent that by just saying it triggers feelings and it triggers biases for individuals. And at the end of the day, what we're trying to do is promote the freedom of equal access and opportunity, the freedom for us to come to learn and see each other and to understand across our differences. And it's going to require, I think, a narrative shift where we can really reinforce these points and help the general audience as well understand what we're trying to do within our spaces of education, which is really serving our common good and our common interests in coming together.
Thank you so much. I want to take this moment and encourage everybody to express deep thanks to both Professor Garces and Professor Bagenstos for their expertise, for their time in sharing their perspective, for their straightforwardness, for not offering us pie in the sky visions, but being really direct about where the situation we're in, the challenges we face, and thinking about how to move forward. In particular, I want to highlight two key things I think that come from this. One is the deep importance of building community, both within and across our institutions. Those of us who committed to this mission of not only access and serving the educational needs of all, but also of academic freedom and the central importance of the educational and research mission of our institutions, not only to our own students and communities, but to the nation as a whole. And secondly, and this builds from Professor Garza's final point, right? We need to be better at articulating what we do, why we do it, why it serves the nation, and what it is not. And I encourage all of us to join in within our local communities within the nation to make those points heard. This has been a part of a series called Dear Colleagues, How Should We Be Leading Higher Education Today? Or that's the next session in the series, excuse me, which will take place on April 25th and feature former President Mary Sue Coleman, President Emerita at the University of Michigan, former President of the the Association of American Universities, as well as of the University of Iowa, Nancy Cantor, current president at Hunter College in New York, former chancellor at Rutgers University Newark, Syracuse University, and the University of Illinois Urbana-Champaign, as well as provost here at the University of Michigan. Robert Sellers, James S. Jackson, Distinguished University Professor of Psychology and Education, and former Vice Provost for Equity and Inclusion here at the University of Michigan, and moderated by Deborah Lowenberg-Ball, Jesse Jean Story Fry, Distinguished University Professor of Education and former Dean of the School of Education here at the University of Michigan, and former President of the American Educational Research Association. Finally, please, I hope you will take a few minutes to complete our post-event survey, which you should find in your browser. A reminder that this event has been recorded, and those of you who have signed up will receive somewhat down the line a copy of that recording. And again, thanks everyone for attending.